In Indian polity, we are going to discuss about the Writ Jurisdiction of India. Okay, so here the meaning of the writ is a form of command. Okay, so we can say that writ power is also known as a commanding power. Okay, so the entire commanding powers were given to the Supreme Court and High Courts in India. Okay, so here writ power means commanding power. So according to the Article 32, the writ powers or commanding powers were given to the Supreme Court. Okay, so according to the Article 32, so Supreme Court can issue the writs. Okay, so total 5 writs: habeas corpus, mandamus, prohibition, certiorari, quo warranto. Okay, so Supreme Court, by using the Article 32 in the Constitution, it can issue the writ or command. Okay, so second one is Article 226. Okay, so by using the Article 226, High Courts also have the power to issue the writs. Okay, so in our India, Supreme Court and High Courts also have the power to issue the writs whenever there is a need. Okay, so according to Article 32, the Supreme Court has the power to issue the writs. According to Article 226, High Courts of India have the right to issue the writs. Okay, so Parliament can empower any other court to issue these writs. Okay, so Parliament only given the power to Supreme Court and High Courts. Yes, so Parliament can empower any other court. It means there are some district courts in our states. Yes, so even the Parliament can empower those courts to issue these writs. So the entire power is given to the Parliament to make any provisions regarding the writ powers. Okay, so at present the Supreme Court and the High Courts of the states have the power to issue the writs only. So there is no other court has the power to issue the writs. Okay, so in any case there is a need to the empower other court to issue the writs, so the entire power is given to the Parliament. Okay, so this is a very important provision in our Indian Constitution. So before 1950, only some 3 high courts have the power to issue the writs. Okay, so Kolkata, Bombay, Madras. So these high courts only has the power to issue the writs before 1950. But at present, each and every high court of the states have the power to issue the writs. Okay. So according to Article 226, it empowers all high courts in India to issue the writs. Okay, so only single Article 226 given the powers to all the high courts in India regarding the writ powers. Okay, so actually this writ power we adopted from the British Constitution. Okay, so we adopted these writs from the British Constitution. So these writs in the British Constitution known as prerogative writs. Here prerogative writs means very special rights in the court of the Britain. Okay, so in Britain, these writ powers were in the hands of king in England. Okay, it means the writ powers were in the hands of king only. Here, the king is the hereditary position. That's why these writs are in the hands of king only in England. Okay, so these writs are very special rights in England. So in England, king is described as the fountain of justice. That's why the entire power of the writs were given to the king or queen. Okay. So we already discussed about the, according to Article 32, the powers were given to the Supreme Court, and according to 226 article, the powers were given to the High Courts of India. Okay, so but there is a difference between Supreme Court and the High Courts according to the writ power. Okay, so it means there are some differences between the High Courts and Supreme Court regarding the powers of the writs. Okay, so the first column is Supreme Court and second one is the High Courts of India. Okay, so according to Article 32, the Supreme Court has the power to issue writs. Okay, so only for the enforcement of the fundamental rights. It means the Supreme Court can issue or given directions regarding the writ powers only in the point of fundamental rights violation. Okay, so here the Supreme Court never issue any writ in the point of other reason. Okay, so it means the Supreme Court has a narrow jurisdiction regarding the writ power. Okay, so whenever comes to the high court's writ power, so high court can issue writs if any violation to the fundamental rights plus other purpose also. Okay, so here the high courts have the wider and broad powers regarding the writ powers. Okay, so high courts can issue writs in the point of fundamental rights violation and other purpose also it can issue any writ power. Okay, it means ordinary or legal rights also any violation, so it can issue the writ power. Okay, so next important difference is Supreme Court has the power to issue writs against a person or government. Okay, so throughout the territory of India. Okay, so if a person belongs to any state, if a person belongs to any territory within that India, so it can issue against any person, but throughout the territory it can issue. Whenever comes to the high court power, within the jurisdiction, within its territorial jurisdiction, for example AP High Court can issue the writ power within the AP state only. Okay, it means AP High Court can issue the writ power against any person, but that particular person within the territorial jurisdiction. Okay, so this important provision was added by 15th Constitutional Amendment Act 1963. So next important power is under Article 32, Supreme Court may not refuse to exercise its jurisdiction of the writs. Okay, it means Supreme Court must use the writ power if any case is related to the fundamental rights violation. Okay, so it cannot refuse to exercise the writ power. Okay, whenever comes to the high courts, so according to Article 226 it is discretionary. It means it can use or it may not use. Okay, so this is the power of the Supreme Court and high courts.